second case on this morning's docket. That is case number 114830 in the matter of Mandelbaum. Counsel, if you'd let the audience filter out before you start, that way you're not distracted.
Yes, Your Honor.
You may proceed.
Thank you, Your Honor. May it please the Court, Michael Serra appearing on behalf of the Disciplinary Administrator's Office. Mr. Chief Justice, with the Court's permission, I would ask to reserve 2 minutes for rebuttal.
2 minutes is granted.
Thank you. Your Honors, this is an original action in attorney discipline. It is a reciprocal discipline case that originated in the state of Missouri, where the respondent is also licensed. On October 28th of 2014, the respondent was found by the Missouri Supreme Court to have violated several provisions of the Missouri Rules of Professional Conduct. A formal complaint was subsequently filed in the state of Kansas on April 8th, 2015. The respondent filed an answer and admitted to the violations. A panel of the Board of Discipline of Attorneys heard evidence on June 2nd, 2015, in which they found the respondent to have violated the Kansas Rules of Professional Conduct as alleged in the complaint. No exceptions were taken to the final hearing report, and so the primary issue before the Court today is sanction. Just by way of background, the violations found were KRPC 1.8a, entering into a business transaction with a client without advising them to seek outside counsel; KRPC 1.8e, providing financial assistance to a client not related to pending litigation; KRPC 1.15a and d, both concerned with commingling of earned attorney's fees in a trust account; and KRPC 8.4c, engaging in dishonest, fraudulent, deceitful, or misrepresentative conduct. The panel has recommended the respondent be indefinitely suspended, but that the imposition of that suspension be stayed and the respondent be placed on 24 months of supervised probation in accordance with his probation plan. My recommendation at the panel was for a 1-year underlying suspension. However, I tend to agree with the hearing panel report that the indefinite suspension is in keeping with the Missouri discipline, and that is also keeping with the normal procedure when we are dealing with a reciprocal discipline case. The probation plan is quite detailed and thorough. I'll be completely honest, I had reservations about recommending probation in this case given the nature of the conduct. However, the respondent's remedial actions as well as his probation plan and putting all aspects of it into effect convinced me that he is a candidate for probation and met the standards. So that would be my recommendation to the Court today, that the Court adopt the hearing panel findings and recommendations and impose an underlying indefinite suspension, but suspend that to 2 years of supervised probation in accordance with the probation plan.
I had some questions about the timeline of the probation plan.
Yes, Your Honor.
According to what I have, there's a document that was filed December 3rd, 2015 with our court, but it's dated May 13th, 2015. And it says probation order.
I believe that
But it appears to be a proposed plan by the respondent. Is that correct?
it is, Your Honor.
All right. And then next there is the final hearing report, which is dated November 17, 2015. And under the recommendations of the panel, it lays out several things, including item 6 on page 15 regarding audits. And it says, within 30 days of the date of this report, the practice supervisor shall conduct an initial audit of the respondent's files and trust account to assure compliance with KRPC 1.8 and KRPC 1.15. Then it says, thereafter, every 6 months, the practice supervisor shall conduct additional audits. And then after that, there is a document that was filed February 29th, several days ago, and it's captioned Affidavit of Compliance with Probation Plan. So which probation plan do you know if is the respondent saying he has complied with? His original, quote, probation order, unquote, or the panel's recommended probation plan?
It is my understanding, Your Honor, and hopefully the respondent can enunciate this better for the court, that he not only complied with his own probation plan, but also the recommendations that were additional recommendations from the hearing panel. The panel was not in favor of the original proposed practice supervisor who would conduct the audits. So the respondent found another one that did meet with my and Mr. Hazlitt's satisfaction, who has conducted an audit and complied with that recommendation of the hearing panel's report.
Okay. The panel recommendation was an initial audit within 30 days, but it did not appear to indicate that was complied with in the affidavit. And I just want to make sure that I'm reading this correctly, or maybe the language shows and could have been a little more clear. For example, it says, Mr. Gerstel, the practice supervisor, has prepared a quarterly report. Yet the plan that the panel talked about was an initial audit within 30 days and then every 6 months conduct additional audits. So am I confusing some different concepts here?
I don't believe so, Your Honor. I think the confusion is that the respondent, his proposed probation plan, which is labeled the order, proposed quarterly reports. The panel recommended the 30 days and then every 6 months. I think that either would be sufficient, but I appreciate the respondent's willingness to undergo quarterly reports. My understanding is practice supervisor is willing to do the same in accordance with the court's order.
And was a 30-day audit prepared?
No, Your Honor, and that had to do with the practice supervisor issue. Mr. Petlon, who's counsel for Mr. Mandelbaum, contacted me and within that 30-day period advised me that they had not found a practice supervisor as of yet and requested additional time, to which I had no objection.
All right. And then I just want to make sure that if we were to approve the probation plan, that we know what that plan says.
Yes, Your Honor, and having looked over both the respondent's proposed plan and the panel's recommendations, there are some conflicts, specifically with the auditing requirements. I would say that given the nature of this case, the more strict plan, if there is a conflict between the two, would be the better of the two. I think Mr. Mandelbaum did get himself in a significant amount of trouble, and more oversight is better than less.
Okay. One last question, and a similar issue arose earlier this week with your office and a respondent, and that was the authority of the panel to require anything to be done. Because in their reports, their caption says recommendations to the Supreme Court. Yet, for example, on paragraph 6 of the panel's order, it says the practice supervisor shall conduct an initial audit. So could you help us through that general issue as you understand it?
My belief of this general issue, and I say that having been with this office for just a little over a year, is that under Kansas Supreme Court Rule 212F, the panel's recommendations are just that. They are recommendations to this court. They are not binding authority. The panel has no authority granted by this court to direct a respondent to do anything beyond the panel report, or excuse me, beyond appearing for a formal hearing. I think the recommendations are just that. They are suggestions to the respondent for additional remedial action they think would be useful and helpful before they appear before this court, but I do not believe their authority extends to order a respondent to do anything beyond their recommendations and finding of facts.
So in this case, it appears the respondent has been very cooperative in trying to comply with recommendations.
Extremely, Your Honor.
Had he chosen to say, I'm not going to allow an audit within 30 days, your position today would be that's his right, and there's nothing that you can do to enforce that or to try to see that discipline is imposed because he's refused to comply with what you say is a recommendation of the panel?
My position is I do not believe the rule permits that. I believe the rule does not permit the panel to issue mandates to the respondent and in their panel report. They are just recommendations if we read the rule as written. I know that does cause some question about the Barker case, which talked about some non-compliance between the issuance of the panel report and appearing before the court, but I think that had to do more with the respondent's failure to appear versus non-compliance. But that case does talk about that potentially being considered as an aggravating factor.
Wouldn't a hypothetical respondent's demonstrated unwillingness to work with even recommended conditions of probation, wouldn't that just indicate that that particular respondent was not a good candidate for probation? And then wouldn't you, at least conceptually, be able to fall back on the recommended discipline of suspension?
I certainly think it could. It also could fall under the failure to cooperate with the disciplinary process, which is yet another violation of the Kansas Rules of Professional Conduct.
Could it be that if the panel has no authority to make an order, how could it be a failure to cooperate?
Well, I think that it all depends on what our definition of cooperate means, Your Honor. I think that if cooperation means following recommendations, that's what it is. If it is not found to be cooperative by just saying I'm not going to do this, which right now the way the rule is written, I think they have the ability to do that. It wouldn't be. I think there is some ambiguity and some gray area here, which probably needs to be resolved. That may need to be resolved through a rule change.
Well, your office could certainly come here and say, look, they have a right not to do what was recommended, but the fact that they've chosen not to do what's recommended means that we no longer think that they're amenable for probation.
Certainly.
Okay.
But again, I think it would be advisory only. This court can take whatever action it feels is appropriate given the facts.
Do we have any further questions? Thank you, counsel.
Thank you, Your Honor.
May it please the court. David Mandelbaum appears in person and with his attorney, Trey Petlin. As Mr. Serra has pointed out, my client's disciplinary problems, like so many others that appear before this court, began with financial problems. Delinquent taxes led to tax levies on Mr. Mandelbaum's business operating account, and then led to a series of bad decisions by my client. The dilemma in his mind at the time was that if he couldn't continue to pay his operating expenses, he couldn't continue to represent his clients, and he couldn't eventually pay his tax debt. So Mr. Mandelbaum began leaving earned fees in his trust account so they couldn't be levied. And everyone agrees that that was dishonest, most notably my client. His motivations were misguided, and his decisions were made under some duress, and he doesn't offer that as an excuse. Mr. Mandelbaum cooperated with the disciplinary process from its inception in Missouri. He turned over all of his bank records, he submitted to a deposition and testified. He put the OCDC in contact with his clients. Mr. Mandelbaum's trust account records and the ensuing investigations in Kansas and Missouri confirmed that he left earned fees in his trust account, and he deposited earned fees into his trust account in another case in violation of rules 1.5A and D, safeguarding property and depositing funds belonging to the lawyer into a trust account. He also violated Rule 1.8A, business transactions with clients. He had one client who deposited funds into his trust account in anticipation of possible litigation, and then gave him permission to borrow against those funds. And that evidence was uncontroverted. She testified both in her deposition and then in the hearing in Missouri. And he did all of that without entering into a written business agreement or without advising her to consult with another lawyer. Her response to the OCDC when she was asked about that was that she didn't need to talk with another lawyer. But of course, that does not absolve Mr. Mandelbaum, and he knows that doesn't absolve him of his obligations under 1.8A. He also violated 1.8E by giving financial assistance to clients. Despite his financial hardship, he gave money, he advanced money to 3 separate clients. He advanced relatively small amounts to 2 clients for payment of living expenses, and more specifically grocery bills, and fines on a traffic ticket. And then he advanced part of the purchase of a motorcycle to one other client who was attempting to use Mr. Mandelbaum's service to help him purchase a motorcycle. And he was repaid by that client within 10 days. The Missouri Supreme Court suspended the respondent indefinitely and placed him on a 2-year probation, which began in October of 2014. He implemented his own probation prior to the formal decision, of course, and he's been under supervision ever since then. His tax debt is not resolved, but Mr. Mandelbaum is doing everything that he can. He's hired Bob McQuain, who is a respected tax attorney, to help him with that and to have a dialogue with the IRS and the Kansas Department of Revenue. I spoke with Mr. McQuain just this week, and the current plan is that Mr. Mandelbaum will be making voluntary payments as much as he can, when he can, and that Mr. McQuain will hopefully be able to put together a formal repayment agreement. An important component of the plan also is that Mr. Mandelbaum will cut back on his spending. Since the Kansas investigation began, he's continued to cooperate, and he's been very candid and honestly described what he did. He's accepted responsibility for his failures. His answer, his stipulations in this case, and his testimony at the panel hearing all reflect that. Of course, he has not filed any exceptions to the hearing panel's report. He's participated in his additional CLE hours as prescribed. He completed an 8-hour ethics program in Missouri put on by the Missouri Bar Association with a class on conflicts of interest just within the last 6 months. The Kansas CLE Commission accepted 5 hours of ethics for that. He's resolved all of his issues with regard to his trust account. He's very, very grateful to have found John Gersley, an attorney in excellent standing in Olathe, Kansas, who's agreed to supervise Mr. Mandelbaum in Kansas. I know Mr. Gersley. I've known him since I practiced, and I've talked to him. He is the kind of lawyer that loves to mentor other lawyers, and he's got experience with trust monitoring, and he's been approved by the Kansas Disciplinary Association or Administrator. He's also willing to spend a lot of time on it, and he will be detailed with his reports. My client's trust account has also been monitored by a practice supervisor and an accountant for his Missouri probation. His trust account is subject to random audits, coincidentally with an audit just this week by the Missouri OCDC. His Mr. Gersley examined my client's trust account a little over 2 weeks ago. All of the reports reflect that my client does not have any earned fees in his trust account, and he does not have any client funds in his trust account that are not for current representation related to his representation. I spoke this week with his Missouri practice monitor with the Missouri OCDC, Carl Shapencotter. I talked to him on Monday, and he said that Mr. Mandelbaum is in full compliance with his Missouri probation and has, quote, done everything that we have asked, end quote. There have not been any subsequent violations since those that are enumerated that the hearing panel found in our hearing in June. My client has been married for 14 years. He's raised 3 children. Despite his financial pressure he faced from the IRS, his representation of his clients has never suffered. He has diligently represented all of his clients, and all of the cases that were examined were resolved favorably in favor of his clients. He didn't commingle funds in the sense that he used client funds to pay his operating expenses or his own personal expenses. None of his clients lost money. He commingled money in the sense that he left earned fees in his trust account. The OCDC confirmed in their investigation that no client funds were converted. Every client dollar in his trust account was ultimately accounted for. There was never a fee dispute, and even nor was there ever a single complaint from a client on any issue related to money or related to Mr. Mandelbaum's representation. His clients were very happy with his work on their behalf. We submitted a number of letters from clients and from other attorneys. Mr. Mandelbaum is an intelligent, skilled attorney who enjoys admiration and confidence from his clients. He has, on the other side of that, he has good clients who have cases that are meaningful to him. In my own experience with Mr. Mandelbaum, he is self-deprecating, but he is extraordinarily upbeat for somebody who has been through the investigations. In part, I think, because he enjoys the practice of law.
Did the IRS take any action on his conduct?
They have not. Mr. McQuain is still on retainer and still trying to...
Is that ongoing, or what is the status? Seems to me they would be interested in the conduct that arose from these actions. What did they do? They're still investigating? That's where it's at?
They're still investigating, and it's still an ongoing dialogue with Mr. McQuain. So that's why he hasn't got a formal repayment agreement yet. My client's working hard for his clients and to address his tax arrearage. And as Mr. Mandelbaum testified at the hearing panel, he is committed to repaying his tax debt, and he's optimistic that he can do that. The hearing panel noted that he was genuinely remorseful, and we know here today that he's not entitled to any concessions from this court, not based on his remedial actions, not based on his the decision of the Missouri Supreme Court. But I do think that there is a lot of wisdom in the hearing panel's recommendation, and I would urge the court to consider that. They're recommending an indefinite suspension with placement of the respondent on probation for 2 years or until his Kansas taxes are paid in full, whichever is later. This will allow for, obviously, for very strict consequences if there are any transgressions. It will also allow the respondent to thrive in his practice, and it will give him an additional incentive, of course, to repay his Kansas taxes as soon as possible. I don't have any additional comments, but my client does wish to make a statement with the court's permission.
Before we do that, I did have a question. Given your familiarity with this case, how many different lawyers are now supervising or auditing or helping your client, Missouri and Kansas combined?
Well, 2 lawyers that are in private practice, then Carl Shapencotter, who is the monitor with the Office of the Chief Disciplinary Counsel in Missouri, and then there's an accountant.
He has a supervising attorney in Missouri as well.
He does.
All right.
And that attorney office is with him, so the Kansas disciplinary administrator wanted to get another attorney that was outside of his office to review, just to be sure that everything was copacetic. And I will say that I got a glowing report from Mr. Gersley.
I wanted to follow that up by saying I think it's a credit to your client that he has so many professionals willing to help him. I'm assuming some for compensation and some without.
In Missouri, there's some compensation, and in Kansas there is not, and he's very, very grateful for that. It does take some time. I know Mr. Gersley, just as an example, spent President's Day with my client.
The other thing that I'll ask either you or your client is what led him to all this? For example, borrowing money from a client. You don't have to answer that specific question, but I'm just curious. There seem to be a lot of things going on here, and I wondered what the explanation is. So you can address that, or he can.
I'll address it to some extent, and then maybe my client will want to supplement my response. But that particular client, he was friends with since 1985, and I'm not certain, but I think he was going through some financial issues, and they were friends as much as anything, and she graciously agreed to allow him to borrow that money. But naturally, his financial stress played a big part in that.
Very well. I would also ask him to address that as well when he comes up. Thank you, Counsel.
Thank you, Judge.
Counsel, you said something that I couldn't remember, and so now I'm looking through here and I can't find. You made a reference that the supervision of the practice would continue until all of the taxes were paid. Where is that condition? I didn't see it in the panel recommendation, so I started going back through the probation order, and I didn't get through it. So what did I miss?
Number 3, recommendation 3.
Of what?
Yes, I'm sorry,
Of the
paragraph
report.
3 on page 14.
Of the report from the panel.
Thank you,
All right,
Chief
thank you,
Justice.
Counsel.
Prior to that.
If it please the court, I'm David Mandelbaum, and I just wanted to address the court and let you know how sincerely sorry I am that these problems have arisen in the first place and gotten to the level that they have. I, as a matter of fact, in 2013 was probably inches away from having all of the tax matters resolved when the trust account issue blew up. I've worked hard to try to address this. I've cooperated fully with both Missouri and Kansas. One thing that I hope you'll notice is that the facts are clear because I've admitted to all of the facts. There isn't a single thing that I've been accused of that I'm going to tell you I didn't do. I went into the private practice of law out of a corporate legal department, and the significance of that is that at the time that I started, I probably wasn't prepared for the things that people have to do in private practice. It's actually been beneficial to be in a position where I'm working with Mr. Gersley. I will say that Mr. Gersley has spent a lot of time with me. I'm very grateful for the time that he's given me, and he has a personality that works well with my personality, and we've been able to work through the things that are expected on this probation. do so successfully, and I think that we'll continue to be able to do that. You asked about Mrs. Fuller. Mrs. Fuller fell into the category of an old friend and is the kind of person that if she were not a client, was still an old friend and might have been somebody that would have offered to help me through a rough financial patch anyway. It so happens that over the years, during the course of our friendship, I've also undertaken a lot of legal work for her, including a lot of things that I had done for her son, who had some problems growing up. And this was a child who I had known since his birth, and we had a very, very close relationship, Mrs. Fuller, and actually my whole family. She is somebody who could be found, having dinner with my wife. So it's that kind of relationship that I think sort of blurred the lines in my mind at the time that transaction took place. As I stand here today, I still have a traffic ticket of Mrs. Fuller's in my briefcase that I'm going to be handling for her. We speak probably weekly. That's what happened with Mrs. Fuller. I left the money in the account because I had hoped to keep the practice going long enough that I could power through this. My plan is to practice law, which I love to do, earn money, and pay the taxes. And that's always been my plan. And, as I said, I thought I was very close. I now actually have a case that's recently come into my office that, with a good result, could resolve this whole thing. I'm hoping that it will.
Where do you currently stand with the IRS?
I still owe the IRS a little better than, I think, $230,000.
And what are they doing in relation to the fraud that took place?
Well, they're doing nothing that I know of right now. Mr. McQueen, has been negotiating with them, and I don't know that they consider that to be the kind of fraud that they would take action on.
So it's right now the focus is on the debt owed as opposed to the conduct.
I believe yes. I think that's accurate to say.
What prompted my question to your counsel earlier, and that you've partially addressed in talking about this client named GF.
Yes.
My question was, what led you down this road? And I asked that question because we would want to make sure that if we did something with you, for example, this probation plan, that when the plan was complied with and we said you are now free to practice law without any restriction whatsoever, how do we know that these problems are not going to recur?
At that time, there had recently been a levy which had taken all of the operating funds out of my account, and a lot of the practice that I have is workers' compensation cases, which tend to be long cycle cases because, of course, you can't have a settlement or a hearing in a work comp case until the client reaches maximum medical improvement or has completed their treatment at least. And so, particularly at that time when I wasn't doing as much hourly paid fee-for-service work, it could be a long time in between checks in the office, sometimes a period of months. And when a check came, usually it was substantial, but then, particularly during that time frame, it might be, 90, it might be 3-4 months in between checks. And so, at that time, those funds were borrowed to meet operating expenses for the practice. I don't gamble. I don't drink much at all. I don't smoke. I haven't taken a vacation in years. I don't have expensive sports cars or expensive hobbies or habits. I'm just trying to run the law practice trying to address these problems.
Maybe my specific question is, how did you come to owe the IRS $230,000 and still owe the Kansas? Was there some large event that created this big tax problem, or is it accumulation of things over time? And my question is getting to my basic point. How do we know this is not going to recur if you get all this paid off?
If I have to trace it back, it starts with, at the time of my divorce from my first spouse, I had a large child support obligation, which I paid at times that I didn't pay rent, that I didn't pay the telephone bill, that I didn't pay, many other things, which included initially, I would have to tell you that it started with the employee withholding, the employee tax withholding not being paid. Then there was an audit that occurred in, I believe it was 2007, at which I think our numbers agreed on reported income in that audit, but a large number of expenses were disallowed, and that initially started with about a $67,000 tax bill from that audit, which then ballooned with penalties and interest. And so, I've since changed CPAs. I've got a gentleman that I believe to be a very good tax accountant who I think is doing good work for me and is staying on top of this, and mainly just staying on top of things and getting things to these professionals that I have assisting me now. And that's what the plan is to continue to do into the future.
Very well, thank you. Do we have any further questions? Any further presentation, counsel?
Not at this time, Your Honor.
Thank you.
May it please the court. Mr. Chief Justice, I have no additional presentation for the court at this time.
Have you been in contact with the IRS at all regarding any of this?
No, Your Honor.
Okay.
I've not been contacted, and I'll be honest, I've made no effort to contact them either.
Okay, thank you.
Unless the court has additional questions for me, Your Honor, I would waive rebuttal.
I see none. Thank you, counsel. Thank you all for your arguments this morning. Court will take this matter under advisement.